being here. Welcome to today's Idea to Impact Forum. This is the fifth of 8 Idea to Impact Forums that we've had, and despite attendance, this is one that people responded and said this was one of great interest to them. So I'm glad that we're able to record it, and we'll make it available on our website for people to see. I think it'll be a very engaging conversations. We worked really hard to line up a knowledgeable panel for an engaging forum today on intellectual property. And for those of you who aren't tuned into that, sometimes we call that IP too. So if we exchange the terms back and forth, don't panic, that's what it means, intellectual property, IP. As ECU begins to embrace and build its innovation culture, it becomes important to consider whether some form of protection is valuable to protect our ideas and intellectual property from use by others without permission. And though the general subject can be very complex, we've worked really hard to try to bring it down to a level that people should feel some degree of comfort with, and maybe take some of the mystery out. So no one here is going to be an expert at the end of today's session. In fact, I don't know that I'm an expert, and I've been working in the field a long time, but we're going to bring it down so you all feel comfortable with it. In preparation for our forum today, the panelists and I gathered around our conference phones and talked about, how we might best craft today's message. IP is pretty complex, but we just want to make sure that you are all aware that you don't have to be an expert. You just really need to know when you need help and where to go to get help. So we just want to give you that comfort. I wanted to kind of give you, if you'll bear with me a little bit, I worked really hard on this, my analogy. This is nothing that we talked about on the other day. But how many of you watched the Super Bowl game this year? How many watched the halftime show of the Super Bowl? And then how many of you watched Katy Perry dancing around with the Sharks? Yeah. Well, so did you notice that the Sharks weren't in sync with each other? Some of them were really doing it just in right line with Katy, and it all looked really good. And then there was one that was kind of off, doing his own thing. The one doing his own thing, I learned, left shark. He was on the left side. He's left shark. The guy who knew what he was doing was on the right side. And I make this analogy because despite all the missteps that left shark made, the show went on and it all worked out fine. And now he's actually more famous than right shark. And I just want you all to know that at some point in our lives and in our careers, we are all left sharks. And that we're just going to have to depend on others to kind of lead us around. The right shark people, I think we've got a panel of right sharks right here that are going to help us. But those are the folks who are going to keep us on track and make sure that we're on the right path. As we move on to the program, I just want to remind you of a few key points that we've heard in some of our previous sessions. I'm not going to go through all of them, but I picked one from each. But we learned that it's not about you. There's something greater about this. We learned to be flexible and solution-focused. We learned that there's no one right path to take. And we learned that it takes the 3 Ps: process, patience, and planning. So we're going to learn some new things today here. We're going to move beyond our sharks and let me start introducing our panelists here today. So here on, I guess it would be your right, my farthest on the left, we have Tim Romack, and he's agreed to be our discussion facilitator today. I snagged on to Tim the moment he landed on campus to serve on the university patent committee. It's a good thing. And I did it for a very good reason. He's a serial inventor and an entrepreneur, and he knows the drill. In addition to authoring over 70 publications and a textbook on polymer chemistry, Tim is named as an inventor on over 40 U.S. patents and numerous international patents. His role as an inventor began as a graduate student at UNC Chapel Hill and was refined while serving as the president of technology development with Micel Technologies. which was a UNC startup company that explores uses of carbon dioxide for synthesis of non-aqueous fluoropolymers. Among its uses is an environmentally friendly method for dry cleaning. I think there's other uses as well, but that's one I remember. So I know if you've traveled to Wilmington, you'll probably have seen the Hangers Dry Cleaning Store, and that the genesis of where it came from was Tim's doctoral research. Tim holds a PhD in chemistry from UNC Chapel Hill with a specialization in polymer chemistry and his bachelor's degree in chemistry from Illinois State University. Prior to that, he served as a petty officer with the U.S. Navy. Tim is currently Associate Professor of Organic and Polymer Chemistry at ECU's Department of Chemistry. And I believe he also has an active consulting practice with regard to patents and other things. Next to Tim, we have Shauna Lemon. Shauna received her Bachelor of Science degree in Biology from Wofford College. I hope I'm saying that right.
That's correct.
And her doctorate in Biomedical Sciences with a concentration in Pharmacology from the University of South Carolina School of Medicine. Shauna received her Juris Doctor degree from the University of North Carolina at Chapel Hill and has been practicing patent law since 2001. Prior to her legal career, Shauna worked in pharmaceutical market development with Merck & Company in their Northeast Business Group in New York City. Shauna serves as outside patent counsel to pharmaceutical and biotechnology management teams in universities, where she engages in the formulation and implementation of global patent strategies. In addition, she has assisted clients with intellectual property due diligence, partnering negotiations, and trademark protection. Shauna is a partner with the intellectual property law firm of Myers-Beagle. She has co-authored publications in scientific journals and speaks to various audiences regarding patent law topics. Shauna has served as the co-chair of the Biotechnology and Chemical Patent Practice Subcommittee of the Intellectual Property section of the North Carolina Bar Association, and she currently serves as chair of the Pro Bono Subcommittee. Shauna, this is new news. Shauna has been named among the best lawyers in America this year in 2015. Congratulations.
Thank you.
And she's named as the Business North Carolina's Legal Elite in 2014. Shauna is a member of the North Carolina Bar and is registered to practice for the U.S. Patent and Trademark Office. We're glad to have you here, Shauna.
Thank you. Glad to be here.
Next to Shauna, we have Will Cannon. Will is a partner with the law firm Parker Poe, and he practices in the areas of technology, internet, and trademark law. He regularly negotiates multi-million-dollar software agreements on behalf of his clients. He also litigates disputes concerning his clients' trademarks and domain names before the U.S. Patent and Trademark Office and the National Arbitration Forum. Will received his Juris Doctor from the University of North Carolina at Chapel Hill in 2005 and his BS from Davidson College in 2002. We're glad to have Will here, and his red tie is really a statement to his ties to Davidson. So we're glad to have him.
Thanks for having me.
With the red tie. Before I move on to Todd, I did want to say that ECU actively takes advantage of outside legal resources, and we have used Shauna and her firm and Will and his firm on a number of occasions to help us navigate some of these difficult waters of intellectual property protection, and when we license to different industry partners for contracts. So I can tell you, I'll admit freely that we are left shark and we depend heavily on right sharks sitting here. Rounding out our panel today, we've got Todd Watkins. Todd earned his bachelor's in psychology from UNC at Chapel Hill in 1985, and following a year of biomaterials and informatics research, he received his DDS from the University of Chapel Hill School of Dentistry in 1990. Todd joined the Dental and Educational Resources faculty at the University of Texas Health Science Center in San Antonio, following completion of an advanced education in general dentistry residency. in 1991. In 1994, he successfully completed his first tech transfer project by transitioning Project Mackenstein from the University of Texas to a Delaware C Corp called VitalSource Technologies. As president and CEO of VitalSource, he guided the development and delivery of the first XML-based electronic book platform, which is currently the most used e-textbook technology in the world. He's been featured in New York Times and Wall Street Journal for his work during the infancy of e-books and digital rights management. After leaving VitalSource, he served as a consultant to numerous health science schools in course and curriculum implementation of technology and content. Todd joined ECU School of Dental Medicine in 2008 as its first faculty member and was tasked to develop the initial curriculum and the technologies needed to implement the dental programs. He currently serves as Assistant Dean for Dental Education and Informatics, where his current research focuses on student, faculty, and program outcomes assessment technologies. Todd was selected as a member of the Apple Distinguished Educators Class of 2013, which is a global community of educators who use technology effectively to help learning. In 2014, his latest tech transfer venture received an exclusive license agreement from ECU for various intellectual property rights related to Extensible Competencies Platform, more commonly known as XCOMP. XCOMP assesses different educational outcomes, such as didactically focused, skills-based, and problem-solving environments. XCOMP proof of concept has been established at ECU School of Dental Medicine and has received high marks during their most recent accreditation visit just a couple weeks ago. So we're glad to have our panelists here today, and I hope you'll agree that we've got an excellent panel here. Before we get started, let me just mention a couple housekeeping comments here. Is that lunch is available, and help yourself. If you need to get up, move around the room, feel free to do so. It's an informal setting. You'll notice that we are being recorded, so if you'll just step around the one camera this week instead of 3 cameras in our other sessions, that'll be fine. I don't think anyone here in this group will be filmed. The camera is fixed, but if you should be filmed by some manner, that will not be posted on our website, so we'll be good with that. The other point I wanted to make is on your table you've got some index cards and pencils. So if you have questions or if you want to take notes, please feel free to do so. And when we get to the Q&A portion of the program, we'll be gathering your questions on the cards. You can hand those cards to either myself, Carlisle, who's manning the camera, and Lucretia, who we met out at the registration table, and we'll proceed with Q&A in that manner. So I guess I probably talked way too much. I'm going to go ahead and turn the program over to Tim, and we'll go ahead and get started on a really good discussion on intellectual property. Thank you.
Great. Thanks, Marty, for introducing everybody. I guess what we thought would be most useful to start out with is for our 2 attorneys, some experts in the legal field, to kind of give us a broad brush picture of, what really is intellectual property. What kinds of things does that include? What kinds of things can we protect?
Sure. So generally, intellectual property is an ownership interest in a product of the mind. So the fruits of your mental labor, you have rights to that. And intellectual property is generally based on patents, copyrights, trademarks, or trade secrets. And for example, a patent is the right to exclude others from making, using, selling, or offering for sale, as well as importing an invention. And there are generally 3 types of patents. There's a utility patent, which is directed to the structure and function of an invention, as opposed to a design patent, which is actually directed to the ornamental aspects of an invention. And then there are plant patents, which are directed to, of course, plants, and that are new and distinct. So those are generally your patent protection. And there's also trademarks, and I know, Will, you have a lot of experience with that. You may want to comment on that.
Sure. So trademarks are essentially your organization's brand. They can cover either a good, a widget, or a service. So East Carolina University has a trademark that it has protected at the U.S. Patent and Trademark Office, and so other people are not allowed to use it in connection with its protected goods and services without getting its permission. There's also copyright, which is really a written expression in some sort of tangible form. So if you write song lyrics, or if you write software code, that's going to be copyright. But if it's a contemporaneous, off-the-cuff situation where we're just talking today, that's not protected by copyright. That's not something that's fixed in a tangible medium. And then the last of the four buckets that Shauna mentioned is trade secrets, and that's really your secret sauce. It's a idea that gives your company some competitive advantage in the marketplace that you're taking affirmative steps to protect. And the most famous trade secret is the recipe for Coca-Cola. And they opted to protect that by a trade secret for a lot of reasons, but one of the big perks of a trade secret is that it's unlimited in duration. So if you have a patent, you have a monopoly for a limited amount of time. If you have a copyright, you have protection, but it's for a longer amount of time. Trade secret can go on as long as you and your company take the steps that you need to. So those are the four buckets. You've got patent, trademark, copyright, and trade secret.
So now, Todd, I know you've had experience in using like all of these tools at your businesses. Do you have anything you can comment on, the different aspects of why you would want to use one or another?
Wow. The last company I created, which we just licensed XComp to AAL in Atlanta. What I've found I've done, we filed 19 patents between when I did VitalSource and XComp and that kind of stuff. You start by, what I found is you come up with the mental idea or the intellectual concept, or what was the term you used in terms of the product of your brain. And the more important thing is to write it down, get it in some type of structure, and then create the time that you did it. So even before you decide whether you're trademarking, whatever it is, you want to, in a certain way, tag, this is when I've actually formulated the entire intellectual idea. Then you start figuring out what the best copyright or the best protection is. First, you have to circumscribe the concept, but that date is incredibly important to you. So when I did VitalSource, we did that. We recorded a video and actually put it in a lockbox with a date associated with it. And that date, even though we had not written formal documents, applied for patents, done anything, it served as the benchmark of when that thought process had come to bear. And if there's one thing I can say is you have all these tools and attorneys and wonderful things, but your ability to protect that time of when you've actually consolidated the idea is incredibly important. Then it buys you the time to figure out how you want to protect the intellectual property. If you wait until it's all perfect and you've written everything and everything's done, time has slipped by and you might have given up an opportunity. And you don't, when you don't know what I would be the left shark, until you don't know where you're going to be with it at the end, giving up time relative to the intellectual property is probably the biggest mistake you can make. So while you're figuring out whether somebody else has done it, whether there's a patent by somebody else, you better benchmark when you did it and then let the processes take place. Does that help?
Yeah. So it sounds like we're talking a little bit more about patents in general. What do I need to have before I can file a patent application? Or what do I, is it just the idea? When do I have to have a working invention or?
Very good questions. So you have to have an idea, of course, but you need to have a complete and operative invention. And when we say operative, you don't necessarily have to make it, but you have to have enabled it. That is, for someone, one of your colleagues or your peers, one of skill in the art, to understand that you were in possession of that invention. That is, you have described that invention well enough that they can go and make and use that invention without undue experimentation because you have described it. So that's when you are deemed to have an invention.
One thing that might be worth following up on is the timing of, if you make it public, what does that mean? How does that affect your rights?
Right, so actually going along with what Todd said about that delay in time, that is very, very important now because this is the America Invents Act. So we've now entered patent reform, and so we're now the first to file as opposed to first to invent. So previously, you can invent, you can conceive in your mind, you can write it down, you could work on it, take your time, and if someone filed before you, you go back to that lockbox and say, hey, look, I invented first. But that doesn't work anymore because we're now a first to file system. So you need to think about that and file your inventions. Also, as Will mentioned, that disclosure. So our patent system, it provides a limited monopoly for you to prevent others from making, using, selling, etc., your invention. In exchange for that monopoly, you provide that information to the public. You're making a donation to the public of that knowledge in order to promote the sciences. However, if you've disclosed it, you've already given it to the public and you can't take it back. So therefore, it's important to protect your inventions, whether it be through some sort of confidentiality type agreement or filing an application prior to making that disclosure and dedicating it to the public.
I guess so. So that brings up the question in my mind of, we're academicians, right? We want to tell everybody about our great ideas. And also, if you ask your chair when you're going up for tenure, well, should I talk to the patent attorney first or should I, publish this? They'll oftentimes say publish it first because you got to get those manuscripts out there. What do you have to do realistically before we can publish things?
Talk to Marty.
That's right.
See the Office of Technology Transfer. That's what I would recommend. Because again, if you're disclosing to the public, then you're dedicating it to the public. Now, there are some disclosures, for example, department meetings or, closed environments that would not be deemed a public disclosure. But it's better to err on the side of caution.
But there's a tension there, right? I mean, there's your career advancement. If you're told publish or perish and you need to publish, then that's a motivating goal. But it eradicates your right to pursue a patent. So you have to make a decision for yourself. Which way do you want to proceed? Do you want to go through tech transfer or do you want to publish? And I think that Marty is a great resource to help you navigate that.
I lived that one personally over the last 3 years. I actually am on tenure track because I was a geek in business. So I'm earning my tenure like a lot of people. When we did the we did the XComp, actually Myers-Beagle, and then I did not feel comfortable publishing, even though I could have, and it would have helped me toward tenure be faster. I felt like it was better to not disclose it until after we had done the filings and we had gotten a certain further amount through. But I made that decision myself because I wanted to protect the intellectual property. But that is the tension. There's absolutely no question that is a tension in academics.
And in some ways, I mean, if you had published, you might have hit a single, but if XComp launches the way that it could, it's a home run. And so you have to have a longer term thought process, and I think that probably was part of your calculation.
And you have to have an administration that understands that sometimes you have to delay the tenure process in order to get, hit the home run. There's no question.
I guess at that point, I could make the comment. I've been on Marty's committee for 15 years now almost. Doesn't seem like that long, but I know that her office and our Office of Technology Development is really good at understanding that people need to get things published, and they're really good at doing everything they can to get things documented, out the door and done on their end so that faculty members can get done what they need to. When you see inventions coming out of the universities or intellectual property coming out of different university settings, what are some of the most common pitfalls you see? I guess to you two, in your practices or whatever that you've observed, and Todd, what are some of the biggest ones you've fallen into? Do you have any thoughts or? Anything come to mind?
Well, I've screwed up about everything you can possibly screw up. So, when I did Vital Source, I was very emotional about it. It was like a child. You create this idea, you're going to create a company, you go through all the issues. The thing I've learned over 25 years is don't get emotional about it, be pragmatic and be logical. You were talking about being problem solving. You're always dealing with, should I protect it and pay the money for the patents, or is it worth it? And deal with that with tech transfer all the time. The other thing is, don't get romantic about what a company is. The theory is that you're doing this patent, you protect the intellectual property, you do the tech transfer. Whatever the resultant company is created, whether you're just creating it to license the technology or you're expecting to run it, don't be emotional about it. Do it, understand that a patent, a copyright, they're just tools. They're business tools that you need in order to commercialize. And the structure of the actual company is just an instrument as well. And it will change depending on what it needs to be. And I was an academic and thought that I could figure it all out, that I was smart enough to be able to sit down with a piece of paper and go, I'm going to do this, and then I'm going to do this, and I'm going to make this company, and this is how much stock, and then I'm going to hire this. Don't do that. Think of it very much as, what's the next process along with it? What do I need to protect? You're always dealing with intellectual property changes, but you're also trying to figure out the best path to commercialization. And I found that the more things that I felt in stone I figured out, sometimes it hurt me to actually implement what I needed to do business-wise. So even though you come up with this great idea and you say, I'm going to create this company, I'm going to run it for 50 years, and it's going to be great, just realize that things change, markets change, and that don't get emotional about it, be pragmatic. And I made both mistakes, I'll be honest with you. I got emotional about Vital Source, and it hurt me for about 3 years making business structure changes that if I look back on now, I would have made different decisions.
For me, in determining inventorship, so in some instances, some contributors to the science have difficulty assessing who's an inventor. So first of all, who is an inventor? An inventor is someone who's contributed to the conception of the invention as claimed in the patent. So let's break that down a little bit. So we're looking at the patent, and if you see a patent, you see that there are these numbered claims at the back of the patent. Those define the metes and bounds of the invention, the limitations of your invention. An inventor is someone who's contributed the idea and the complete thoughts and operative invention as recited in that patent, in those claims. It's not just someone who's worked on the invention, or someone you really like, or someone who's nice, or someone who's, I don't want to get in trouble here, but the department chair, so we want to just make sure that person's named. They must have made a contribution. And that's very important because several reasons. It can invalidate your patent. It can render your patent unenforceable. And as Todd's mentioning, if you're trying to sell the technology or license the technology, when you undergo due diligence, that acquirer wants to know, okay, do you have assignments? Who are the inventors? Because at the end of the day, this is a business interest of theirs, and they don't want someone coming out of the blue saying that they have rights to this, because that puts everything in jeopardy. So it's very important to determine inventorship and understand who an inventor is and make that determination correctly.
I think resisting the urge to talk about it is one that I see a lot. And do you represent the Undercover Colors guys from NC State?
I do not.
We do not either. All right, Hutchison does. So there are these guys at NC State who
Just make sure.
Yeah, just to make sure. They came up with an idea for a fingernail polish that girls can wear out to bars, and if their drink has a date rape drug in it and they drop their fingernail polish into it, it'll turn bright red. And that's a great idea, right? I mean, that's an idea that really has a nationwide, worldwide market. But they're on TV 10 minutes after having the idea, WRAL, News and Observer, their Triangle Business Journal, those guys are everywhere. They didn't go through the Office of Tech Transfer. They hired attorneys privately, and they've raised $1 million, right? So maybe I'm wrong about this, but I have concerns about whether they actually have anything beyond the trademark undercover colors, whether they actually have patented technology. And if you're a fingernail company, Revlon is one. I mean, you just see that idea and you say, I'm taking that. That's in the public domain. So just having some discretion about, you might have a great idea, but you don't have to market yourself immediately.
And getting non-disclosures. I mean, that was another thing that I screwed up. So guys, making sure that you get a good non-disclosure structure written. You can't always just use a boilerplate. I mean, there's this theory of, well, get me a non-disclosure and I'll just sign your mutual. A lot of times the technologies that you have need to be more specifically defined than in a boilerplate. And boy, I wish I'd done that differently. So when you go out and you're actually disclosing, make sure it can't be just, okay, we're going to meet with you, we trust you to sign the non-disclosure and send it to us. You don't have the meeting if you don't get the mutual non-disclosure. And guys, I'm just telling you, don't screw that up.
And taking that a further step, if you transfer any material,
yeah,
do that under agreement
email
as well.
Watch your emails. Just make sure, just putting it's confidential at the bottom, nah. If you're disclosing it, you're disclosing it. So,
and an example of Todd's point, yesterday I looked at a contract that one of the big electronics companies in the U.S. was asking our client to provide their technology for them to take a look at. And they said, look, here's our mutual non-disclosure agreement, sign it, we'll take a look at it where everything's above board. But the term of the confidentiality duration was 1 year. And so 1 year and 1 day later, this enormous company no longer has any obligation to keep it confidential. They just sit and play four corners, and then a year later, they've got your technology. So I think that's a great point, that the boilerplate NDAs are worth reading.
Also where it's enforceable. I mean, if you sign a mutual with another company and they're where they can litigate it is in, I don't know, Utah and whatever. You got to be careful that they're playing on your ball court because you can get in trouble really fast signing mutual non-disclosures just because you're really excited about a big company being interested in your cool idea. Those NDAs are unbelievably important.
That's an article that I should write, so I'm going to take your intellectual property, having announced that. That's on my to-do list now.
Yeah.
That's good.
So Todd, in your comments Will, in your comments a minute ago, I was looking at Todd, you mentioned something that kind of caught my interest. You talked about people for undercover colors using outside counsel.
Yeah.
I mean, do we have any legal ownership issues we have to deal with as a faculty member and being an employee of the university?
That's a great question. These were students, and that's the big difference, is that it wasn't faculty members where there's a claim that it belongs to the university. They were students that participated in NC State's incubator program, but ultimately weren't university residents, employees.
But yes, you do.
But yeah, I mean, that's a huge issue. Todd probably can speak better to it than I can.
Well, I mean, the reason why I had theories of what became XComp a while ago, but I wanted it in a university. And it's really odd. You would think, oh, well, he's created companies before, so why wouldn't he just hire an attorney and do it? The technology I was creating needed to be in an academic institution. I think I talked to you about that, Will. And so I knew on purpose that when we did the tech transfer, we would be going through the Office of Tech Transfer with the legal issues and sharing. But I felt like that's what I wanted to do with that technology. When we did Vital Source in '94, I actually had the attorneys from University of Texas in Austin come knock on my door and said, your research looks more like product development. We would feel a lot more comfortable if you would take it out. I think it depends on the technology and it depends on the intellectual property. I felt like what I wanted to do with XComp was to actually have it be in an academic institution, but you have to make that decision. If you decide to go outside, you still have the responsibility of working through the university in order to get it free and clear, and those are other issues. Those are pretty easy to do, and University of Texas was great when I did the Vital Source transfer. Let me be clear with that. They were great. But at the same time, it depends on the technology, and it depends on what you're going to do with the company. There's no real answer, but yes, if it is within the university, there's a report of invention that goes to the university, and then there's a decision the university makes relative to how they want to protect it. And Marty in Tech Transfer is very, very good at that. So, like I said, I've helped with 6 tech transfers and 9 companies. Our university is very good at handling this, and I'm more than happy if anybody has any questions about that, to be a resource.
So in other words, the ownership part of it can be a little complicated, and we should work with folks at the university to make sure that we take the right path there. Now we've been talking mostly about patents. Why don't you guys speak a little bit, Will, to some intellectual property for an academician as it pertains more to copyright and trademark?
Sure. So copyright is nice because you don't have to file something in order to have the copyright. So unlike patent, where it's first to file, or trademark, where if someone else hears your idea and they're in a different geographic location, they may be able to start using that mark. If you publish something, you own a copyright to it, and you can enforce rights. That said, if you obtain a copyright registration, and they're pretty cheap to get, it's $50 or $100 to file, and then you have certain access to the courts, certain statutory damages, and there's some advantages there. But the pressure is not on with copyrights the way it is with patents or trademarks or trade secrets.
How does that apply to software, for example?
Yeah, so software is the trickiest. I mean, we treat that as a trade secret a lot of the times, and it's often a complicated question whether you're going to call Shauna or call me, right? Because there is software that is patentable, and there's software that you may opt not to patent. And Shauna, you may be able to speak. I don't know if that's right in your wheelhouse, but that seems like a key gating question that I encounter a lot.
Right. So I am a life sciences attorney, so I don't do much in that space. But a couple of things. So you file a patent application. It takes at least 3 years, if that, to have it issued. So in terms of software, you got to look at the life. Is that, by the time your patent issues and you have your protection, you're on to the next thing. It's obsolete. So sometimes patents aren't the best route for that type of technology. Also, as you guys may be aware, there have been recent Supreme Court decisions calling into question what is patent eligible. For example, laws that are abstract ideas in business methods. These things are being called into question as being laws of nature or abstract ideas, etc. And also the Bilski decisions. These things are saying simply because you add a computer, you really haven't done much to take it out of the realm of being a law of nature. So those are really affecting the patents in that space right now.
This is in my wheelhouse because that's what I do is software development, and so the real thing to pay attention to is the architectural schema of the software. So, for instance, when you write code, what the platforms on which the code is built on is more important than the actual lines of code from a copyright standpoint. So you got to be really, really careful about somebody saying, oh, well, we'll just change this basic schema structure and then I can get around your copyright. So the way you write software patents and software copyrights, there's a trick to it, and I can tell you, I've done it well and I've done it poorly, and it's an art unto itself, and we could do an entire session on it. So if anybody's actually interested in that, I mean, I understand code structures relative to how to get it through intellectual property, and it is its own game, just like Will was saying. It is, you have to be really careful. You also have to, when you're doing the code, save it in various iterations based on the way the patent attorneys actually like it to be done for software patents, and make sure that you have iterations of the code along the way that you can prove how you did the structure. Like I said, if anybody's really interested, it's its own entity. I'm more than happy to talk to you about that.
But one good thing about software is that you can protect it contractually, and you
Yeah.
can use these click-through agreements. And I draft these click-through agreements, so I know how incredibly onerous they are. But people click on them regardless, and so EULAs, right? So
Yeah.
individual license agreements. So the other night, my wife and I were signing up for Care.com, and we got halfway through, and there was a pop-up agreement. And I was checking it out. It was impressively onerous, right?
It
Just to
is.
get a babysitter. You're giving up all this rights to your information. My wife said I was a huge nerd for spending the time reading it, but that's an option, right? So if you have software, work with an attorney. You can require users before they ever install it to click through, and then you're protected from the trade secret side.
Yeah,
and from the copyright.
writing the EULA is as important as the non-disclosure. I mean, I'll be honest with you, that one is worth the money to get done well. So if you do software, that's money well spent with an attorney to get the EULA written well.
So I guess one other thing I heard in there was make sure we read everything that was signed and click off on, right?
Easier said than done.
And
sure.
Ancestry.com.
Right.
So, Sean, you mentioned things that we're eligible for filing a patent application on. What's eligibility all about? I mean, what are the things that are eligible and are not?
Well, that's a very good question because recently that has come into question. So basically, generically speaking, any new useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof is deemed to be patent eligible subject matter. That's very, very broad. However, you do have those exclusions that I mentioned earlier, the laws of nature, such as the law of gravity, natural phenomena, just wild animals out there as an example, and then abstract ideas. So those are not deemed to be patent eligible. However, again, one of the recent case laws that you may be familiar with are the DNA patents, so the breast cancer genes. So up until fairly recently, you could patent an isolated gene. That's no more. So in that particular case, the Myriad Genetics case, where we're no longer able to patent isolated genes. And that's a new thing, and that's a really big deal right now. So, but you can patent what we're calling non-naturally occurring genetic material. And again, now what's being called into question are, like I said, some of these software type patents, some of these business type patents, if they're deemed to be abstract. Also, in the life sciences, diagnostic type claims. Many of those have been invalidated by the Mayo versus Prometheus case. That's a relatively recent decision because they're saying those are merely laws of nature. All you're doing is observing a natural correlation. And so that's called those types of patents into question. So currently, this particular environment, we're really in flux with regard to what is eligible for patenting. And very recently, as of December, there are the USPTO interim guidance that are trying to help us determine what is patent eligible, but it's really deemed confusing by many of us patent practitioners. And we're waiting for what we call the actual guidelines to issue because they're accepting comments from practitioners and elsewhere to try to figure out, okay, we're confused here. What is really eligible? So that question, several years ago, easy to answer. Today, not so much.
So it sounds really complicated.
Yes.
Well, also the business implications. So you're trying to take tech transfer out and make some money off of it for the university. The overnight when the ruling came out about relative to BRCA genes came out, genomic stocks went down almost 75% just overnight, which means that venture capital doesn't want to invest into a sector that you've been kept from owning intellectual property in. So just to understand, like I said, don't get emotional. Dude, you spend 5-6 years of your life coming up with an isolated gene, and overnight there's something that keeps investment capital from coming in. You can get emotional really quick. So just understand, these are not trivial issues. As soon as they make a decision like that, it can absolutely slash the value of what you had. So strike while the iron's hot.
So let's say I do have a patent and they get it issued and so forth. And that means that nobody can do that, what I've got patented, right?
That's correct.
So they just look at that and they don't do it, or what do I have, I mean, how does that work? In other words, do I have to do anything? If I have a patent application, or if I have a patent that's issued and somebody's doing what I thought I patented, well, who has the responsibility to do something about it?
Well, you're in litigation. You want to speak to that?
Yeah, I don't personally handle patent litigation, but let me address that from the trademark side. So if you obtain a trademark registration, if we're East Carolina and someone opens up down the street and uses our mark in connection with identical products and we don't do anything about it, then we start to erode our trademark rights. And so you're only as strong as your efforts to police your marks. And so it pays to have an attorney using monitoring services and to send out cease and desist letters. You don't really need scalps at the end of the day. What you do need is a folder with a bunch of cease and desist letters in it, so that if you're ever in a courtroom situation and someone is pressing on that point, you say, look at these steps we took. You want to have a case to make for your argument. So on the trademark side, I push people as hard as I can to focus on enforcement. That often gets lost in the shuffle. They pay for the registration and then they don't want to see you again until the renewal's due in 5 years. But I think that you take that approach at your peril.
I remember one time, the interest I was involved in was thinking about patent litigation. And we were talking to a relatively prominent trial attorney about it, and he said, why don't you go burn $1 million cash in your fireplace while you think about it, because that's what it's going to cost to even get into this with a large company. And so, that side of things, my guidance in the past has been only if it's really worth a lot of money and a lot of your time and energy. But you, Todd, have you had any experience with any?
Just relative to internet domains too. I mean, so you go to all the trouble to brand, you get the trademark, you better make sure you've got, because somebody's going to be out there slamming you in the internet domain area at the same time. So, remember Marty talked about Mackenstein. She said, transferred Mackenstein. We were going to get a trademark on Mackenstein at University of Texas because we thought it was cute and I had a cool logo. Boy, did I screw that up, and should have gone down that road, because almost immediately after it went out there, this is 1992, and I should have protected it, but we didn't. And it was just, and then domain names became huge, and just making sure that your brand, if you are going to hang your hat on a brand, make sure you're paying attention to both the internet domain as well as the actual stuff, because business, if the brand's useless if you don't have the marketing around it, and so you might as well go all in at that point. And it's really hard to do the searches. If you do the search on your term, then other people are looking and they'll buy the domain name just to keep you from accessing it.
Right. And one thing to be aware of is that we're all used to using .com, .net, .edu,
Yeah.
but there are new global top-level domains that are gradually being rolled out. And in a couple of years, we're going to be in a situation where there's 1,000 of them.
Yeah.
And right now, there's a period where people can register, kind of put their flag in the sand so that other people can't come in there and take them. And so you want to keep an eye out. So .bank is the big one that's coming out soon. .college is one that my university clients are interested in. Companies have to make a decision whether that's going to be useful. I mean, I tend to think of it like streets on a map. And so the main street is .com, and maybe the side streets are .net. But where are these other ones going to be? Is it going to be good real estate where you have customers walking past your place, or is no one ever going to go there? And right now it's just not clear because that system's not launched. I do a lot of brewery work, and .beer came out, and they were bullish on .beer. They think that that's going to be a street that people walk down, but we just don't know.
But to your point, Tim, with respect to patent litigation, yes, it is indeed very expensive. And so you're thinking, okay, I had this patent, but it's going to cost me all this money to enforce it. What good is it? Well, in some instances, it's going to be expensive on both sides. So it's likely that there may be a license agreement. And that may be more favorable an alternative to litigation.
So that addresses things about what cost of litigation. What about cost of getting into the game? Like, for example, trademarks versus patents versus copyright and so forth. I mean, and a patent application can cost $10, even $15,000 or $20,000 to file?
It sure
And
can.
then add up to.
It sure can, and that's just in the U.S. and to file internationally. That, oftentimes you can file directly into a country, or what's called the PCT, Patent Cooperation Treaty, which is an international application. And then you file that application for now. This may change very soon, but for now, you have to then file into many different international countries, and that's very, very expensive.
So like a couple $100,000 over
Absolutely.
a period of a few years?
Easily.
So patents take quite a long time to get done and cost a lot of money to get done.
Yes, they do.
Also, you pay attention to the weird countries that you're really worried about them ripping you off. In other words, it can be a preemptive strike to file in a specific country, but at the same time, you've got to make sure that country actually has a decent enough government to actually honor the patents.
Right.
So you don't want to spend, for instance, when we did XComp, we decided not to do Egypt, even though we had potential customers in Egypt. They didn't have a demonstrable government, and we weren't really sure that it was worth the effort if the patent goes to something that doesn't actually exist. So, you're making those decisions
Right.
as business decisions.
I'll tell you an example of that. We had a resort client who was filing a trademark in St. Kitts, and the trademark lady who was the trademark office, her hard drive crashed, and the trademark office closed. They didn't fix it. They didn't recover it. It's just there are no more trademarks in St. Kitts. And so you got to be careful in some of these countries about.
So it'd be cheaper to actually borrow a new machine and send it and open the office up so that you can get the trademark.
No, that's right. But in terms of like actual prices, if you're going after a trademark, you budget $1,500, $2,000.
Yeah.
That's a lot of bang for your buck, I think, on the front side. If I were telling you what two things should I do early on, you file a trademark and get a confidentiality agreement. And you can do both of those for under $5,000. And I think that's a lot. They get you a lot of the way down the field. Then you can start making determinations if you're going to call Shauna and really back the Brinks truck up and lock down that patent protection.
Okay, so I guess we're getting a little bit close on time. Todd, any last words on, a take-home for someone who might be thinking about pursuing some avenue that would be governed by intellectual property?
The one thing we didn't talk about is the money of actually forming the entity if you do it. So if you go to all the trouble to do the patents and all the filings, you ultimately hope to commercialize it in some way, shape, or form. So also keep in mind the money that you're going to have to pay to build the structure of the entity itself. And those may not be the same attorneys, but they usually are within the same group. And I could spend hours just talking about the screw-ups I did forming companies. There is smart money to be spent. And so, for instance, the building your corporate structure and understanding, just like you're talking about EULAs and that's smart money to do. The other thing is if you do the business plan, go ahead and write a private placement memorandum and do a good job of a private placement memorandum even before you take the first venture into the company. So in other words, you have an entity to bring even if it's angel capital up front, that you get $200,000 in angel capital or something, go ahead and write a private placement memorandum to take that money so that there's a basis for the equity. And so if you think about it, this is the beginning of the process, but you're never finished with intellectual property protection, and you want to think about budgeting enough money in order to form the entity well. And doing it well, you can screw up all the money that you spend on your patents if you don't have the business structures done right. And so, again, I've screwed everything up in my life. I'm more than happy to be a resource to try to keep other people from screwing up. But at the same time, there is smart money to be spent, and attorneys are your best friend. And while I've been here, just let me be clear, been involved in 9 tech transfers at multiple universities. This university is young at it, but they are very good at handling some of these things. So I'm more than happy to be a resource, but you've got Marty and her team. They're excellent at what they do. And we want to be really good at this. And so, we're young, but I think we could be really good at it at this university.
Okay, and I guess in listening to a lot of what folks have brought up, I guess what I think what I take home is, number one, that all these things are relatively complicated and well beyond anything I'm ever going to be an expert in. Another one would be that Tech Transfer Office is not necessarily a stumbling block or something that I have to get through. It's a resource I can use to get done what I need to, and the good place I can get guidance and get connected with the right folks and decide which avenue I need to pursue. Maybe I'm just interested in licensing something. And also that there's some incredibly good resources around campus that we can all take advantage of.
And you can do this. This is not impossible for you to do. And that's the take home.
I was told once too that it may not look pretty behind the scenes, but it's like a good restaurant. It doesn't matter what gets thrown in the kitchen as long as what comes out pleasantly and is edible by the dinees. Any last comments from anyone? Okay, I guess Marty, it's back to you now, right?
And let's give them a hand. I think 45 minutes isn't enough time to get around this topic, but I think that we had a really good discussion here today. Before we turn to questions and answers, I wanted to just point your attention just briefly here to this table over here, because we brought examples of some patents here so you can kind of get a sense of what a patent looks like. We've got them from any number of countries. Some you won't be able to read because I can't read them unless, do we have anyone who reads Mandarin, Japanese, Korean? Because we got those over here. We do have a U.S. patent. We have a copyright as well. And I have some really fun examples of, I think, trademark, because we've got a Coke can written in Arabic, and I looked at it and I knew it was Coke. I also have a pack of Oreos. I don't know what that means in trademark word.
I don't know.
They came from Egypt. If you've got questions, pass them to Carlisle or bring them on to me. I've got a few to go ahead and get started. Here's one. How is benchmarking your idea protecting it if you still don't have a patent?
So,
Maybe that means documenting it.
okay, yeah, so benchmarks, so documenting your idea? That's just a note-keeping type thing. Todd, did you want to speak more to that for actually preparation of the patent?
Like, I guess part of it kind of depends on whether you're making a widget, you're building software, you're making a process. So engineering, for instance, they have, how do I build a filter and those types of things. When I've done it every time, I started with the basic structures and proved each one of the pieces would work. And then the final process before I filed for the patents, I could make all the processes work as one. So a lot of the early stuff is to make each one of the pieces of it and document those individually, knowing that you're going to try to do it. And then I use could I make the entire system work at one time? I see engineers do the same thing with chemistry, that you can actually prove a process. But I felt like I had to make the entire thing work all at one time before I felt like I could go to the patent process.
And so that's having the operative invention.
Yes.
But as far as actual patent protection itself, that's not really relevant.
I guess in my own experience, one of the most valuable patents that I had any inclusion in didn't have a physical reduction to practice before the patent was filed. It was a complete idea, and so then filing the patent was as good as actually doing it, because it wound up working.
You learn a lot by writing the patent too. I mean, seriously, writing the proper patent takes a lot of effort in getting the pieces done, and that actually helps you operationalize the business at the same time.
We've got a lot of really good questions here, so we'll just move on. I think this is really a patent kind of question about obviousness, and which is one of the criteria for patenting. Is obviousness all based on patents and publications? How about blogs, Facebook, do-it-yourself websites? Do they limit you?
They do not limit you. And unfortunately, it's even common sense now. So whatever one of ordinary skill in the art would deem as common sense, that is now involved in the obviousness indication for rejection. And so, as Marty mentioned, there's novelty, there's obviousness. And obviousness, novelty relates to one piece of prior art. Every element of your invention is found in that one location, whereas obviousness is a combination. And that combination includes, as the question mentions, anything that's publicly available prior to your invention.
So many good questions. This one's kind of interesting. Cybersecurity has become a hot topic since Sony was hacked. How can you protect your IP if it is released out of your control due to a security breach?
Bad news.
Trademark.
I mean, it's thievery like anything else. So the key is to make sure origination of, if they steal something out of a document, so let's say you build a Word document, it creates so let's say you're going to put the idea in a Word document, make sure that you put it in a fresh Word document with the date timestamp. If it's ripped off, you can go back into the originator code of the file and actually get it. People don't realize that, but there are two forks in every file, and the originator is always in the binary file. So I do know of people that have gone to the binary fork in order to prove that it came out of their computer, even though something was stolen. But cybersecurity, man, it's bad news bears. It just,
Yeah, some protection under trade secret law, though, regarding that, don't you? I mean, if somebody hacks in your computer and takes something, they're in violation of trade secret law.
Yeah, the trick is finding them, right?
Yeah.
So if you can find someone and prove that they did it, then you have unlimited opportunities to pursue recourse directly from them. But a lot of this is happening from
China.
Eastern Europe, Russia, China, Africa, and you're never going to find those guys. And if they take your secret recipe for Coke and publish it on the internet, you've lost. So I think that's that should urge you to think about cybersecurity and act proactively.
you were talking about first to file, but there's also first to business. So one of the ways that you create it is, so for instance, if China steals it, then there's got to be an incentive for them to actually take it and turn it into a business faster than you could do it. So the key is to speed to market and making sure that you lower the threshold for them to actually want to turn it into a commercial product by you having such a service or a product already out there that's doing it, and therefore you protect with the trademark and all that kind of stuff. But I mean, you're constantly feel like you're in a dead race. I mean, I hate to put it that way. You come up with a great idea, you do all the protections, you still feel like there's always somebody chasing you, because there always is somebody chasing you. So make sure that you get out there and are trying to take a commercial product as fast as you can, because the best way is just prevent them from actually commercializing it faster than you can.
How does the new patent law affect GMO foods?
I have to say, I'm not sure about that one.
It'll be interesting with feed corn, right? They've had this whole thing about feed corn. So the idea was that in certain parts of Iowa, they actually were selling GMO feed corn, and then they started planting it and finding out that it was getting in other crops, and then making additional changes. I think what you're saying, this gets into the natural laws issue, and I think that was one of the big issues is, can you patent genetically modified food? I just find it fascinating. I think it's going to be the genetic modifications. How many people up the road in GlaxoSmithKline are doing genomics drugs that just got eaten by the BRCA gene issue? We're in a brand new world, guys, on that kind of stuff, and it's going to be fascinating. When I read those new patent laws and listened to the NPR, I think it's going to be fascinating. I don't know.
Well, again, the issue is, if it's non-naturally occurring, then you're going to be okay.
The problem is we now don't know what naturally occurring is. So you create it, you plant it, and it crossbreeds with another crop. Who the hell knows what natural is anymore?
Well, see, and that's part of the reason why when we draft claims, we indicate a certain percent sequence identity, because there's going to be some natural modification as you're trying to exclude those, but you don't necessarily know, you can't necessarily do that. So we really don't know what's going to happen.
So if I get intellectual property protection in the United States, what's that mean in other countries?
It's a great question.
But the one thing it does mean is you can't bring that product from another country into the United States, but it doesn't do anything for what they're doing in that country.
Yeah, I've had big companies that were launching a trademark that they were concerned, they're big enough that when they move, people are watching. And so we've done 100-country rollouts where you'll simultaneously file the trademark applications. You'll have a conference call with local counsel in 99 other countries, and you have to account for time zones, and you got to say, all right, file. And that way, if someone's watching the trademark registries, which they are, they won't have the opportunity to jump in. But if you file in the U.S., I mean, it's uncommon for people to file in the U.S. and also file internationally, but just know that you risk having your trademark swiped if that's the approach you take.
That doesn't cost
Assume
$1,500,
patent's the same.
does it?
Sorry?
So that doesn't cost $1,500 to do that.
It gets expensive, really expensive.
That's fascinating to me, because in the patent process, when you file PCT, you basically do it with one sheet of paper and can begin the process. So you don't have to, ultimately you have to have counsel in all those countries, but I don't think you need to sit on the phone and time the exact moment
Right, no.
you push the button. I never gave that much thought to trademark.
Yeah, there's something in the trademark world called the Madrid Protocol, and some countries have ratified it and some have not, and some important ones have not.
One last question. So if I get a patent, I can quit my job, right? And the money will start rolling in, right?
Don't get emotional, because it doesn't work that way. I mean, patents are mechanisms, they are not cash machines, unless they're rare. I mean, you will find some that are the retirement patents, but you're not doing it for that reason.
Right, someone has to find your patent valuable, otherwise it's just a very expensive publication.
Yeah, agreed.
That's it for questions today. Let's give a hand to Tim, Tom, Bill, and thank you all for being here. I think this was a really valuable and important discussion. I know that this is sort of a high-level discussion on intellectual property. Our office has created an inventor's handbook, and it's on our website, but I do have copies of sort of the IP section over here on the end of the table, or you're welcome to take them with you, and that might help answer some additional questions that you have. I also want to thank Aramark, Office of Innovation, Economic Development, and Research and Graduate Studies for sponsoring us today. This is the kind of commitment that we need to have this kind of dialogue here. And I also want to thank my staff, Lucretia Davis and Carlisle Rogers, who have been outstanding here. I have a special treat to tell you about that I think you'll find really interesting. Is this Monday, March the 23rd, we have a patent examiner coming to campus from the U.S. Patent and Trademark Office. He will be here Monday over at Mendenhall at lunchtime. Lunch will be provided. It's an outstanding opportunity because next week is Research Week for the campus, so it's a big celebration of research on campus. And Monday, I think the highlight is graduate research. So that's open, and I think you'll enjoy hearing him. Our next forum is Idea to Impact Forum is noontime on Friday, April the 17th, and this forum will be talking about industry partnerships. So I think that'll be really good. I think I can invite these guys back if I wanted to, if you're free. But anyway.
I screwed those up too.
Joining us, we've got Dave Brown from the Department of Physiology. Dave has successfully leveraged research that he has done with industry and his data collection and such, and now has leveraged that for some NIH funding, which in today's world of federal grant funding, that's a big deal. That's a really big deal. So we're glad to have Dave here We'll also have somebody here representing, we have an industry partner here who will talk to us about what it's like from their perspective on collaborating with universities. And actually, next month, I'm going to trade my hat and sit over here with the panel and talk about sort of the licensing side and the university side of industry relationships. So I think it'll be a really good discussion and you'll enjoy it. Let me say, so I guess that's it. I do want to remind you that we have on the table survey cards inside your little flyer or your brochure here. We've got an announcement about the patent examiner coming, and we also have the survey. So if you can give us some feedback about today's programming and some feedback on what it is you'd like to see going forward, that would be very helpful for us to assess, the quality of our programming and what we might do in the future. So again, let's give our guests a big hand of applause and thank them for coming here today.